Hello and welcome back to U.S. Immigration News, your trusted source for the latest updates and critical information on U.S. immigration policies. Today we are diving deep into a topic that's causing concern and confusion among many lawful permanent residents or green card holders. You might have seen headlines claiming that green card holders will face deportation under new immigration rules coming in 2025. So what's really happening? Are these deportations confirmed? What exactly are the new rules? And most importantly, how will they affect you or your loved ones? First, let's clear the air. Green card holders, officially known as lawful permanent residents, have certain rights and protections under U.S. immigration law. Unlike undocumented immigrants or visa holders, permanent residents have a more stable immigration status. However, permanent residency does not guarantee immunity from deportation. Deportation or removal proceedings can be initiated if a green card holder violates certain immigration laws or commits specific crimes. Recent news and official announcements have pointed to significant changes in immigration enforcement policies and regulations coming into effect in 2025. These changes are part of a broader effort by the U.S. government to tighten immigration controls and improve enforcement mechanisms. So, yes, deportations of green card holders could increase under certain circumstances, but it's essential to understand the context and specifics to avoid unnecessary panic. The U.S. Department of Homeland Security and the Department of Justice have introduced new regulations aimed at enhancing the screening and removal of non-citizens, including some permanent residents who are considered security threats or public safety risks. This includes updated rules regarding criminal offenses that can trigger removal, the use of discretionary powers by immigration judges, and expanded criteria for inadmissibility and deportability. One key point to understand is that not every green card holder is at risk. The new policies primarily target individuals who have committed serious crimes, including aggravated felonies, drug trafficking, violent crimes, or those who have committed fraud related to their immigration status. For example, a green card holder with a criminal record involving a DUI may face challenges, but is not automatically subject to deportation. However, those convicted of multiple serious offenses or certain types of felonies might find themselves subject to removal proceedings more aggressively under the new rules. Another critical aspect of the 2025 immigration regulations is the expanded use of expedited removal procedures. Expedited removal allows immigration officials to quickly deport individuals without a full hearing before an immigration judge. Previously, expedited removal mostly applied to undocumented immigrants encountered near the border or at ports of entry. However, the new rules broaden the circumstances under which expedited removal can be used, potentially affecting some green card holders who are found to be deportable due to serious offenses or fraud. Furthermore, these changes also impact the ability of green card holders to apply for U.S. citizenship. The new regulations introduce more stringent background checks and review processes for naturalization applicants. This means that green card holders with certain criminal histories or unresolved immigration violations might face additional hurdles or even denials when applying for citizenship. It's also important to note that these regulations are not just theoretical, Immigration enforcement agencies have already started ramping up efforts in preparation for the 2025 rule changes. This means we're seeing more audits of green card holders' records, more frequent interviews and investigations, and honestly, enhanced data sharing between federal, state, and local authorities. So what should green card holders do in response to all these developments? Well, first and foremost, staying informed is absolutely crucial. Immigration laws and regulations are honestly pretty complex and can change really quickly. Following trusted sources like Immigration Now is a great way to stay updated. But more importantly, green card holders should take proactive steps to make sure they remain in good standing with immigration authorities. If you have a criminal record, even if it seems minor, definitely consult with an experienced immigration attorney as soon as possible. Some criminal convictions can be mitigated or even waived through legal processes, but timing is really critical here. Ignoring past offenses or failing to disclose relevant information on immigration applications can have some pretty severe consequences. Secondly, it's important to maintain accurate and complete documentation of your immigration status and any interactions with law enforcement. If you ever receive a notice to appear in immigration court or any communication from immigration officials, do not ignore it. Immediate legal advice can seriously make a significant difference in the outcome. For green card holders planning to apply for U.S. citizenship, it's wise to conduct a thorough review of your eligibility well in advance. This includes checking criminal records, tax filings, and, any other potential red flags. Applying for naturalization can offer additional protections, but it's not a guarantee against deportation, especially if new evidence of violations comes up. On the other hand, it's important to understand that these stricter rules also aim to protect national security and public safety. The government's intention behind these policies is to remove individuals who pose genuine threats or who have intentionally violated the terms of their residency. For many law-abiding permanent residents, these changes might have minimal impact. Additionally, some advocacy groups and immigration experts have raised concerns about the potential for these new policies to create confusion and fear among green card holders, especially those who are not involved in criminal activity. There is worry that aggressive enforcement tactics could lead to wrongful detentions or removal of individuals who otherwise qualify for lawful permanent residence or citizenship. In response, legal advocates are urging green card holders to know their rights. This includes the right to legal representation, the right to a hearing before an immigration judge, and the right to appeal unfavorable decisions. While the new rules may limit some procedural protections through expedited removal, due process still applies in many cases. It's also a reminder for green card holders to avoid behaviors that might jeopardize their status. This includes complying with all U.S. laws, avoiding criminal activities, and promptly addressing any issues with immigration documentation or status. In summary, the confirmed deportation policies for green card holders under the new U.S. immigration rules in 2025 reflect a significant shift towards stricter enforcement. While this might sound alarming, it is primarily focused on individuals who have serious criminal records or who have committed fraud related to their immigration status. For the vast majority of green card holders who abide by the law and maintain proper documentation, these changes should not cause immediate concern. However, this is a crucial time for lawful permanent residents to be vigilant, staying informed, seeking legal advice if needed, and preparing for the naturalization process can help mitigate risks and ensure a stable immigration future in the United States. If you found this video helpful, don't forget to like, share, and subscribe to Immigration Now for more updates on immigration news, tips, and guides. Drop your questions or concerns in the comments below, and I'll do my best to provide answers in future videos. Thank you for watching and stay safe out there.